The court in a 6-2 decision held that race-based admissions are a violation of the Constitution and a violation of the Civil Rights Act. For too long, the gatekeepers of post-secondary education have treated applicants differently based on the color of their skin. For far too long, within the walls of our educational institutions, generations of Americans have been taught to accept the theory of eugenics as normal. This theory assumes that as a race, Black Americans think with their skin, that based on their skin color, they are monolithic in their politics, reasoning, and most importantly, their intellectual potential. Those who do not fit within certain expectations and boundaries are considered traitors to their race. The theory of eugenics has a prescribed baseline of expectations. This baseline accepts as a fact that the white race is inherently and intellectually superior, privileged, and destined to dominate other races. It also views the Black race as inherently hopeless, hapless, and forever broken due to slavery 200 years ago. Not taught in our educational institutions is our proud history as national leaders in our love of faith, family, the free market, education, and our country. Americans are always shocked to hear that the Black community once led our country in categories of success that all communities sought after. During the 40s to 60s, Black men led our nation in percentage matriculated from college, commitment to marriage, and percentage of entrepreneurs over 40%. We had a thriving community of which between 50 to 60% message this racist attack of low intellectual expectations. Thankfully, the Supreme Court has recently granted us a major win for equal opportunity and for meritocracy, the two principles essential for the attainment of the American dream. Students across America, whether Black, white, Hispanic, Asian, or other, can now realize their potential without fear of overt racial discrimination or subtle bigotry. We're already seeing small changes due to race-blind, merit-based acceptance that are slowing the insidious pace of the radical left's agenda. For example, Columbia Law Review temporarily froze hiring because of the court's ruling disrupted their long-standing practices of selecting senior editors based on race versus merit. Columbia Law Review has since resumed hiring without unfairly discriminating, and hopefully more law schools will follow this example. As our nation celebrates the Supreme Court's ruling, we must remain diligent in identifying those who are defiant, those who, despite the Supreme Court's ruling, are determined to implement unconstitutional policies of affirmative action. There remain administrators who have expressed their intent to selectively ignore both the substance and the spirit of the Supreme Court ruling. Americans should never accept the subversive attempts to preserve race-based admissions, and I promise you, this congressional body will not. Chief Justice John Roberts was very clear when he wrote, and I quote, "Despite the dissent's assertions to the contrary, universities may not simply establish through application, essays, or other means the regime that we hold unlawful today. What cannot be done directly cannot be done indirectly. The Constitution deals with substance, not shadows, and the prohibition against racial discrimination is leveled at the thing, not the name." So let me repeat, and I quote, "What cannot be done directly cannot be done indirectly." So to those institutions who think the Supreme Court ruling is a pretty please ask, this committee will keep a close eye on the 2024 application process as it unfolds. Racism, hidden or overt, will not be tolerated by this oversight body. Today's admission process must not resemble yesterday's. Further, we will watch as the rulings disrupts the landscape of other race-based institutions across America, as they have been also put on notice. The Constitution is colorblind. Civil Rights Act is colorblind. In these tumultuous times, we should all be grateful that our democracy is steadfast, dedicated to treating everyone equally under the law, regardless of race, creed, color, or zip code. With that, I yield to the ranking member's opening statement. Ms. Scott.
Thank you, Chairman Owens, and thank witnesses for your testimony today. Our nation still has a compelling interest in fostering racially diverse campuses, and the Supreme Court ruling and the Harvard UNC cases does not change that. In fact, it was the Supreme Court in 1978 in the Bakke decision that established that institutions could pursue a diverse student body to advance academic freedom and consider race as one of many factors to evaluate prospective candidates. And while the consideration of race as one of many factors in admissions is vital, it's important that we put the conversation in appropriate context. Of approximately 4,200 degree-granting institutions in the United States, less than 100 selective schools consider race as a factor in admissions, and only 10 consider race as an important factor. Before the adoption of race-conscious admissions policies at the University of Texas at Austin in 2005, black students never made up more than 4.5% of the freshman class. But following implementation of race-conscious admissions procedures, blacks, Hispanics, and Asian Americans enrollment increased, as did classroom diversity. Narrowly tailored race-conscious admissions practices actually level the playing field and counterbalance discriminatory admissions factors that are otherwise in play, such as standardized tests and legacy admissions. For example, the district court in the Harvard case illustrated how recruited athletes, legacy applicants whose families have a history of donating money to the school, and children of Harvard faculty make up a large percentage of each admitted class. In fact, while the applicants make up less than 5% of these applicants make up 5% of Harvard applicants every year, they constitute 30% of the applicants admitted each year, and nearly 70% of these applicants are white. Research also shows that standardized tests many institutions require for admissions have a discriminatory impact, and in fact produce scores that correlate more with students' income, zip code, family wealth, socioeconomic background, and parents' educational attainment than the student's ability to succeed in college. To blindly allow the use in admissions without further examining their discriminatory effect is in fact unacceptable. So when my colleagues across the aisle say they want a system based on merit, I agree. But the problem is the current system is not based solely on merit, and without policies to counterbalance the discriminatory factors, the outcome of the system will remain discriminatory. After the Supreme Court's ruling in June, the administration's responsibility to eliminate disparities in higher education and achieve diverse learning environments did not end. And I called on the Department of Education to issue comprehensive guidance to ensure schools and colleges fulfill their Title VI obligations and address existing discriminatory factors in college admissions now that the discriminatory factors are not counterbalanced by affirmative action. Now, one tool we could have is to achieve equal opportunity would be the Equity and Inclusion Enforcement Act, which has been pending in Congress for several years, and it would restore the private right of action for students and parents to bring disparate impact cases under Title VI. We also have pending the Strength and Diversity Act, which Representative Jayapal and I reintroduced this Congress to provide resources to states or school districts that want to voluntarily develop plans to integrate their public schools. Finally, if we're serious about expanding access to higher education, then we must focus on ensuring that the system is available to all. That means instituting reforms such as those that we have proposed in the Loan Act, which will make going to college more affordable for both current and prospective college students. Justice Sotomayor said it best in her dissent. Ignoring race will not equalize a society that is racially unequal. What was true in the 1860s and again in 1954 is true today. Equality requires acknowledgement of inequality. Thank you, Mr. Chairman, and I yield back the balance of my time.
Thank you. Thank you so much, Mr. Scott. Pursuant to Community Rule 8C, all members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. 14 days after the hearing, which is October 4th, 2023. And without objections, the hearing record will remain open for 14 days to allow such statements and other material reference during the hearing to be submitted for the official hearing record. I'll now turn to introduce our four witnesses, distinguished witnesses, and thank you again for being here. The first witness is Ms. Allison Somi, who is a legal fellow at the Pacific Legal Foundation located in Arlington, Virginia. Our next witness is Mike Zoe, who is president of the Asian American Coalition for Education in Orlando, Florida. Our third witness is Mr. David Inosoa, JD, who is the director of the Educational Opportunities Project and the Lawyers Committee for Civil Rights under Law in Washington, D.C. And our final witness is Mr. Delano Squires, who is a research fellow at the Richard and Helen DeVos Center for Life, Religion, and Family at the Heritage Foundation, which is located in Washington, D.C., and who is testifying on his own behalf. We thank the witness for being here today and looking forward to your testimony. Pursuant to community rules, I'd like to ask each to limit your oral presentation to a 5-minute summary of your written statement. I'd also like to remind the witnesses to be aware of your responsibilities to provide accurate information to the subcommittee. I would first like to recognize Ms. Somin. Is that on?
Now?
There we go.
Okay.
Thank you.
Chair Owens, Ranking Member Scott, distinguished members of Congress, thank you for the opportunity to present testimony on behalf of the Pacific Legal Foundation. We're a nonprofit legal organization that defends Americans' liberties when threatened by government overreach and abuse. I want to make 3 main points today. The Students for Fair Admissions decisions were important because they uphold the vital principle that individuals should be treated as individuals and not on the basis of their race. 2, follow-up litigation is necessary to realize the promise of these decisions. 3, the Education Department's guidance is a missed opportunity to inform schools of their important obligations in this area. Under the Constitution and Title VI of the Civil Rights Act of 1964, government and recipients of government money may not discriminate based on race. Before Students for Fair Admissions, there was a limited exception for universities to achieve a compelling interest in student body diversity. But universities largely slipped the leash of the Supreme Court's opinions and used race very broadly. The Students for Fair Admissions plaintiffs challenged this exception, bringing one case against Harvard University and a second against the University of North Carolina. The court held that these universities had not met their burden. As the Chief Justice wrote, each student must be treated as an individual, not on the basis of her race. Many universities have for far too long done just the opposite. And in doing so, they have concluded wrongly that the touchstone of an individual's identity is not challenges bested, skills built, lessons learned, but the color of their skin. Our constitutional history does not tolerate that choice. That's not likely to be the end of race preferences in admissions. Chief Justice Roberts anticipated schools would use proxy discrimination to evade the opinion's core prohibitions. The majority acknowledges that universities may consider admissions essays about how a student's race affects her life. But it also firmly states that universities may not simply establish through essays the regime held unlawful in the case, and further quotes an earlier Supreme Court opinion. What cannot be done directly cannot be done indirectly. Unfortunately, the early evidence suggests evasion is going to be rampant. We see statements of intention to defy the ruling from the deans of major law schools, from presidents of universities, and even the statements of state governors telling universities in their state that they can safely ignore the decision. If these evasions go unchecked, Students for Fair Admissions guarantees of equal treatment will ring hollow. At the Pacific Legal Foundation, we've been fighting back against proxy discrimination at the K-12 level. Several other attorneys from there and I represent the Coalition for TJ, a group of parents challenging a re-engineered proxy discrimination admission scheme at top science and magnet technology school, Thomas Jefferson High School in Fairfax County, Virginia. In the summer of 2020, Fairfax County restructured its admissions process to in effect, lower the numbers of Asian American students that could attend TJ. The text messages and emails produced in discovery make it clear that admissions was restructured because of, not in spite of, these effects on the numbers of Asian American students there. Yes, Fairfax County's discrimination was of the proxy kind, not the direct kind. But it's no less pernicious and certainly no less hurtful to the kids told that they couldn't go to their dream high school because of their race. Right now, that case is pending before the Supreme Court on a petition for certiorari. My PLF colleagues also have 3 other cases pending in the pipeline in the federal appellate courts involving proxy discrimination at high schools in Boston, New York City, Montgomery County, Maryland, that all follow the same general pattern. While litigation by nonprofit groups is an important way to enforce the core promise of Students for Fair Admissions, it's not the only way. The Department of Education has an important role to play in making sure that the civil rights laws are followed. Unfortunately, the frequently asked questions document that the Office for Civil Rights issued following the Students for Fair Admissions decision indicates they're not going to do that. It basically ignores the large and looming problem of proxy discrimination and essentially tells universities that whatever they want to do is fine as long as they're not too open about it. That's not right, that's not the law, and these universities need to be held to account to realize the core American promise that individuals should be treated as individuals and not on the basis of their race. Thank you.
Thank you. Now, Mr. Zoe.
Yeah. Chairman Owens and distinguished member of Congress, I'm Yikong Mike Zhao, a survivor of Chinese Cultural Revolution, during which my family endured political persecution, devastating personal loss, and extreme poverty. In 1992, I came to America as a poor foreign student. In this land of opportunity, I achieved my American dream, later become the Director of Global Planning at Siemens Energy. Through affirmative action, as shown in Appendix A of my testimony, colleges use higher admission standards, de facto racial quotas, and racial stereotypes to discriminate against Asian American applicants. This discrimination unjustly created unbearable study loads, stress, and psychological harm to our children. Many Asian American applicants even hid their racial identity when applying to colleges. In 2014, I and other co-founders of Asian American Coalition for Education, AACE, started our journey galvanizing Asian community to support Students for Fair Admissions for its lawsuit against Harvard and UNC. AACE and partner organizations filed civil rights complaints against Harvard, Yale, and other colleges. We organized rallies, encouraged students to join the lawsuits, and filed 5 amicus briefs in support. Today, our alliance has grown into over 300 organizations nationwide. This June, the Supreme Court rightly struck down race-based affirmative action. This is a historic victory for Asian Americans, as our children should no longer be treated as second-class citizens in college admission. This is also a historic victory for all Americans, as the ruling will help restore meritocracy, the bedrock of the American dream. It will also advance America towards a colorblind society, as Martin Luther King dreamed of 60 years ago. However, advocates of diversity, equity, and inclusion have not given up. On August 14th, Department of Education and Justice issued guidance that advocates continue to use race and race proxies in outreach and other programs. This guidance again misses the point. The root cause of racial disparity in college enrollment is the failure of the K-12 education, particularly in inner cities, to prepare Black and Hispanic children for colleges. Improving K-12 education is a better and a constitutional way to enhance racial diversity in higher education. Further, while America is faced with a STEM talent shortage and all K-12 education is behind other industrial nations, the Biden administration irresponsibly suggests colleges should further eliminate objective and rigorous admission standards. In response, AAC issued a policy statement attached as Appendix B, where we urge American colleges to stop the use of race and race proxies in college admissions, adopt a blind rating system by hiding students' names and other information that would disclose race, make students' race data inaccessible to admissions evaluators, base admissions criteria on the needs of educational program, not racial diversity or equity. Restore standardized testing as major criterion in admissions. The troubling fact is, today nearly 81% of all colleges have made standardized testing optional. In China, I witnessed that during Cultural Revolution, Chairman Mao abolished the national college entrance exam in order to achieve class equity. After destroying the meritocracy, Chinese colleges produced millions of revolutionaries who could not conduct research or managing enterprise. As a result, China's innovation stopped and its economy collapsed. America cannot afford to repeat this mistake by destroying meritocracy in the name of racial equity. When our nation is faced with unprecedented competition from international rivals, it's imperative to restore meritocracy in our educational institutions in order to maintain America's technological leadership and economic prosperity. The Supreme Court's landmark ruling provides historic opportunity for American colleges to correct their mistakes by promoting equality and meritocracy. I hereby call upon federal, state, and local governments to support our policy recommendations to do just that. Thank you.
Thank you, Mrs. O. I'd now like to recognize Mr. Eno Hosi.
Good morning, Chairman Owens, Ranking Member Scott, and members of the House. Good morning, Chairman Owens, Ranking Member Scott, and members of the House Subcommittee. My name is David Hinojosa, and I'm the Director of the Educational Opportunities Project with the Lawyers Committee for Civil Rights under Law. Thank you for the opportunity to testify today on the Supreme Court's decisions. The Lawyers Committee has been a leader in the fight for racial equity, access, and justice in higher education for many years. We have worked with coalitions nationally in two Midwestern states to ensure that all students may access, be supported, graduate, and enter the workforce fully prepared for our pluralistic society. We have also had the distinct privilege and honor of representing an incredible multiracial group of students and organizations in the Harvard, UNC, and UT Austin cases, including Black, Latino, and Asian American students. Together with pro bono law firms, Asian Americans Advancing Justice AAJC, and the North Carolina Justice Center, we represented the only students who have bravely testified in the UNC and Harvard cases about the tremendous academic and social benefits of diverse student bodies. When I argued the UNC case in the Supreme Court last October, I carried with me their powerful stories of resilience, unity, and determination. These included Luis Acosta, a child of Mexican immigrant parents who wanted to become a doctor after visiting his grandmother as a young child in Mexico and seeing her with an abscess in her knee because she lacked access to adequate health care. Luis had to fight his way into AP classes at his rural high school in North Carolina because a counselor did not think he could compete. Luis had strong grades but did not have the highest test scores because he did not even know that he could study for the SAT. Luis persevered, and today he is in his 4th year of medical school. And Sally Chen, a child of Chinese immigrant parents who grew up in San Francisco in a 1-bedroom apartment with her family and siblings. Sally often translated for her parents in stores, schools, and doctor's offices. She thought about whether in her application she should discuss her family story and decided that she would be true to herself and share those experiences that inspired her. She was admitted to Harvard as a first-generation student, graduated, and now helps lead work with the Chinese for affirmative action. And Andrew Brennan, a second-generation Black college student who grew up in Kentucky and wrote in his college application that he didn't always fit into the Black stereotype because he identified as gay and did not just listen to rap music. He is among less than 125 Black men in his class at UNC. Andrew graduated, continued as a strong advocate for student voice, and today is enrolled at Columbia Law School. These are only a fraction of the deep, profound stories of many of our students whose range of academic and social achievements, attributes, experiences, and talents, including those impacted by race, were fully vetted under affirmative action admissions plans and still should be fully vetted today. These students earned their seats, succeeded in school, and are now succeeding in life. Our country needs more success stories like these, and we cannot allow others to use the Supreme Court's tortured history of the Equal Protection Clause and the promise of Brown v. Board to take those seats away from other well-deserving students. Because let's be real, that's what many supporters of the decision want to do, and not just in education, but all facets of life, where built-in, unearned, and bought-up privileges for the few determine who has opportunity and who does not. That may be somebody's dream, but that's not the American dream. Universities can do their part by instituting comprehensive reforms, including race-neutral programs, recruitment and outreach, and student support, as well as deconstructing systemic barriers, but we need Congress to do its part in helping to bring unity, opportunity, and justice for all. We have several of these recommendations in our written testimony, and I'll just highlight a couple. Providing grant funding to analyze and implement fair and meaningful race-neutral alternatives that advance fair access and opportunity. Increasing Pell Grant funding and expanding eligibility. Increasing dedicated funding for social and academic counselors in K-12, and investigating systemic barriers to higher education, such as legacy admissions and the consideration of biased SAT and ACT exams for admissions and scholarships. Thank you.
Thank you, Mr. Hinojosa. Appreciate it.
Hinojosa. Thank you.
Last but not least, I'd like to recognize Mr. Squires.
Good morning. My name is Delano Squires, and I'm a research fellow in the Richard and Helen DeVos Center for Life, Religion, and Family at the Heritage Foundation. I would like to thank Chairman Owens, Ranking Member Scott, and the subcommittee for the opportunity to testify this morning. The views that I express in this testimony are my own and should not be construed as representing any official position of the Heritage Foundation. The predictions of gloom and doom in a world without racial preferences resonate with some people only because affirmative action has been debated for over 40 years, but is still largely misunderstood. For starters, racial preferences were most common at highly selective universities like Harvard, Yale, and Stanford that admit less than 10% of their applicants. They were less common in schools like Virginia Tech or the University of Missouri that admit well over half of their applicants. During the 2018 federal court case on this issue, Harvard's Dean of Admissions acknowledged that the school used different standards based on race to determine which prospective students receive recruitment letters. The university ranked applicants using an academic index comprising SAT scores and grades. These scores were broken into deciles, where the first decile is lowest and the 10th is highest. Harvard's own student data prove the school's two-tiered recruitment efforts were reflected in its admissions decisions. For instance, a black student in the 4th decile and Hispanic student in the 6th decile had a higher chance of being admitted than an Asian student in the 10th decile. In the words of Justice John Harlan, the lone dissenter in Plessy versus Ferguson, our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The Supreme Court struck down the use of racial preferences in college admissions because they subjected Asian and white students to higher standards than their black and Hispanic counterparts. But what of the claim, held by many progressive commentators, that eliminating these policies will return America to a pre-civil rights era of segregation and discrimination? It's simply not true. The highest performing black applicants at Harvard have close to a 60% chance of being admitted. And for legacy black students, that number rose to 99.9%. Put simply, no selective university is turning away black students with the top grades and test scores. The main issue regarding race and enrollment at Harvard is that 75% of black and 57% of Hispanic applicants are clustered in the bottom 3 deciles, compared to 16% of their Asian American and 24% of their white peers. The solution to this problem is higher performance at the K-12 level, not racial preferences at the collegiate level. Pity and paternalism do not lead to equality. Equality cannot be enforced through mandates or quotas. It cannot be declared through fiat or executive order. Any other policies that apply different standards based on race in order to achieve demographic representation only reinforce inequality because it is impossible to lower expectations and raise performance at the same time. If we want to cultivate a truly diverse college campus that passes constitutional muster, we must pursue several long-term strategies at the K-12 level. First, promote and advance education choice, specifically through options like education savings accounts, which have been implemented in Arizona, Arkansas, Florida, Iowa, North Carolina, Utah, and West Virginia. Second, local policymakers should create pathways for gifted students to receive progressively challenging work in school, as well as specialized education programs outside the classroom. Third, we need to focus on one of the most important drivers of educational outcomes, family structure. Decades of research have strengthened the conclusion that children raised in homes with their married biological parents have better academic and behavioral outcomes than children raised in any other family arrangement. But today, 40% of American children are born to unmarried parents and 23% live in single-parent homes, the highest rate in the world. Any attempts to improve education outcomes, whether on a K-12 or post-secondary level, must include changes in policy and culture that encourage marriage and strengthen families. This is why some schools are looking for ways to incorporate the success sequence into the classroom. Students need to know that people who finish high school, secure stable employment, and marry before having children have a single-digit poverty rate by their mid-30s. The takeaway for politicians, policymakers, and pundits should be clear. A student's family, home environment, study habits, and school quality play a much larger role in determining their academic outcomes than their skin color. Public policy should reflect these facts, not be used to socially engineer outcomes in ways that violate basic constitutional principles. Thank you very much for your time and attention.
Thank you, Mr. Squires. Under Committee Rule 9, we will now question witnesses under 5-minute rule. I will begin the process. Mr. Squires, in this subcommittee, there's been many discussions what diversity should mean. Too many people focus exclusively on identity diversity. In contrast, you've spoken about a need for a wider net diversity. What is wider net diversity, and why should it be a standard adopted to today's college campuses?
So put simply, when I talk about wider net diversity, I'm talking about extending and expanding opportunity to groups or individuals who may not have access to opportunity at a particular time. But the key for wider net diversity is to uphold the same standards across the board. Now, a perfect example of that from history, and where we could talk about real racial discrimination, I would say would be the Tuskegee Airmen, who obviously could not serve as aviators because of racial discrimination in the armed forces. But when those opportunities came, they demanded that they had to meet the same standards as their counterparts. And in fact, obviously they have a stellar service record and won the United States Air Force's first Top Gun competition in the late 40s. Now, wider net diversity I would contrast with lower bar diversity, which seeks to prioritize superficial identity categories in order to create a demographically representative population. So I'm always for wider net, and I think that lower bar does anyone a grave disservice.
Thank you. Ms. Soman, after the Supreme Court's decision against race-based admissions, some colleges and universities seem dedicated to continue the race preferences. If universities are practicing affirmative action called by another name, why should the courts consider these policies illegal?
Thank you. The name does not matter. What matters for the purposes of the law and the purposes of justice is whether or not universities are discriminating on the basis of race. If they're discriminating on the basis of race in admissions, even if they call that discrimination something else, it is illegal and they should be held to account.
Interestingly, faculty hiring has also been subject to race-based preferences. George Mason University published draft recommendations of a plan to enact race balancing by hiring staff to reflect the democratic diversity of the student population through diversity cluster hiring initiatives. This is just one example of professors being weeded out not by their expertise, but because they don't fit the university's imposed racial makeup. Given the Supreme Court's recent decision, do you think race-based preferences and faculty hiring also Would you consider that legal or not legal?
So the decision doesn't directly address race preferences in faculty hiring, but at public schools under the Constitution and under Title VI, which prohibits race preferences by recipients of government money, and Title VII, which generally prohibits race preferences in hiring, yes, racial preferences in hiring are generally illegal. While I believe the decision doesn't directly speak to it, the decision does change the climate and make it clear that the current court is not going to sit by and tolerate discrimination based on race.
Thank you. Mrs. O, there are many who believe that racial discrimination in college admissions is a thing of the past, but you hear from exceptional students every day of being denied admissions despite their academic qualifications. Can you provide an example of a student harmed by racial discrimination in college admissions?
Sure. Just this week, we received a complaint from an outstanding student called Standing John. He is a talent in programming. You know, everybody says computer science is the future for a 21st century. He was hired directly from high school by Google, but rejected by 16 America's top schools like MIT, CMU, and he has outstanding credential academic performance. He also started up a e-signing startup, Rabbit Sign. He won the final list of major global programming competitions. I want to say it's a shame. Our colleges should welcome him because we have STEM talent shortage in this country. But it's appalling for the colleges to ignore this kind of talents. He already filed a civil rights complaint 2 days ago. I hope the U.S. Congress will support his equal treatment complaint.
Thank you. I'd like to now recognize Mr. Takano.
Thank you, Mr. Chairman. Mr. Zhao, I want to understand more about your definition of meritocracy in college admissions. I'm speaking in the context of liberal arts undergraduate programs. You seem to want to return to a heavy reliance on standardized testing for admissions decisions as a fair and a reasonable approach. Am I correct in that?
No, actually, AAC support holistic evaluation,
Okay.
but it should be based primarily on objective, like measurement, like standardized testing, plus like leadership, other things. Very importantly, our educational.
So thank you for your response. So how much would you weight standardized testing in the process?
It depends on educational program. For example, for STEM education, that will be weighted very heavily.
Sir, I want to confine our conversation to admittance into liberal arts institutions such as Harvard, a liberal arts undergraduate. That's an important part of our educational system. So how much would you say Harvard would be allowed to weight or should weight standardized testing?
I think it will be a major criteria among
major
many
criterion.
others.
So would that be more than 50% of the weight, less than 50%?
I don't have the number for that, but we should
But
not
I think it's fair to
eliminate
say that you would
objective.
weight, your emphasis is on objectivity. So we know that grades can sometimes be subjective depending on which school, that the grade may or may not be. But is it fair to say you would weight testing as more than 50%?
No.
No.
For liberal arts, probably not that high, but for STEM education, it should be very
Okay,
important.
we're not talking about STEM
Sure.
education. We're talking about a liberal arts undergraduate program.
I said.
So what is fair in that case?
Sure, I agree. Should not be weight more than 50%.
More than 50%.
But we
Thank you.
need.
So more than 50%. So that would mean that students that score the highest should be given greater preference. So people who score in the top decile, you would say that's a fair system?
I support a holistic evaluation.
But can you answer? But holistic. But your definition of holistic means that more than 50% should be weighted.
I did not say more than. I said could be less than 50% for liberal arts. But I believe for STEM education.
So it could be less than 50% for liberal arts. So
Yep.
So what other objective criteria are there? So grades, would you say, are objective?
Grade, yeah, but the grade is not consistently across the board,
That's right. How would you measure leadership ability?
Leadership can be measured by students take leadership roles in different clubs, but also depends. If, say, a business management, absolute leadership is important. But if, say, like a physics...
Would you say it's difficult to measure leadership objectively through some measure? Is there an objective measure for leadership?
No, that's
So
the
there's
reason
not.
we
So
want objective
I would
measurements
conclude,
there.
sir, that you really think that you say several times that we need to return. You criticize the fact that you say over 1,000 universities dropped the requirement for students to take an objective standardized test, and you say that's you give that reasoning. You attribute that to the fact of the COVID-19 pandemic and George Floyd's tragic death. So do you think that George Floyd's death caused the universities to drop the objective?
No,
Well, you say in the wake, I'm quoting you, in the wake of COVID-19,
but the
George Floyd
advocates took
took
advantage of that. The
Pardon me?
advocates of racial equity took advantage of that.
Well, my recollection is that the universities couldn't rely on the SAT because the test could not be administered because of the proctoring and large numbers of students taking these tests was a danger to public health.
Yeah, but it's time to restore that.
But you want to attribute it to George Floyd's death. That's kind of a curious thing.
No, I said that advocates, took advantage of
Well,
that.
it's curious that you would say that George Floyd his death was the reason why universities
No, I did not
closed.
say that. Advocates of
You
racial
actually-
equity,
it's in your testimony,
took
sir.
advantage of that. That
It's
is
in your
in my
testimony, and
statement.
I want to point that out to you. It's in your testimony. Well, there's much more questions I'd like to ask, but I don't think you're being completely genuine in your answer about how much you would rely on an objective, quote-unquote objective measure, such as standardized testing in the admissions process.
I was saying
I
you
yield
need to
back,
be
Mr.
part
Chairman.
of a
I
key
yield back.
measurement. Depends on educational program. Should give different weight based on the educational program.
The gentleman's time has expired. Mr. Grossman, you're recognized for 5 minutes.
First of all, I'd like to thank all you for being here today. I want to explore a little bit what is behind this drive for so-called diversity, or this tremendous obsession with where one's ancestors come from. As I understand it, and we can ask really either one of you here, as I understand it, the drive for diversity is based on forms that people fill out as to what their ancestry is. If, for example, I have a Peruvian grandmother and was raised in a northern suburb here, I could fill out a form and say I'm so-called Hispanic, correct? And for diversity purposes, I would be labeled Hispanic, correct?
Who did you ask? I'm sorry.
Okay, we're here talking about diversity, and that diversity is defined ethnically, okay, by where somebody's ancestors came from, correct?
Yeah.
Okay, which means, for example, that if I apply to college and I have a grandmother who was from South America, I could check on the form that I am Hispanic, correct?
That is
Mr.
correct.
Grossman, I think people are saying, to whom are you addressing your question?
To Mrs. Summon there.
Yeah.
Yes.
Right. And could you explain to me, because they say what they're looking for here is diversity. Now, I may have never been south of the border. I may not know a word of Spanish, but I'm filling out the form that I'm Hispanic. What type of diversity would I be bringing to that institution? Or how would the fact that I had a Peruvian grandmother give me a different viewpoint that would enrich that institution?
So I think you've put your finger on something very important, which is that universities have tended to emphasize skin color or ethnic diversity over true diversity of thought.
Is there any diversity there at all? I mean, that's what I don't understand. If I have a Peruvian grandmother who, for all I know, died before I was born, the whole edifice is built on the idea that, therefore, I am going to bring a different viewpoint or something to the university.
I agree that it is very concerning that many universities seem to have relied on crude stereotypes rather than looking at true individuality and at the full depth of an individual's experience and what they cast as diversity. Universities should care about individuals and individuality rather than reducing students to their ethnic or racial identities. I'm glad the Supreme Court ruled the way it did so that we can get back to a focus on treating individuals as individuals.
Okay. Elizabeth Warren, when she wanted to become a professor at Harvard, she claimed that she was apparently partly Native American, apparently on the idea that therefore she'd bring a different viewpoint to the faculty lounge. Could you even imagine wildly why she should get preferences for that job based on presumably a different viewpoint in the world, or something that she would know that other students would not know?
So I'm not familiar with the details of how Senator Warren views her identity. However, I agree that it's concerning that these preferences tend to reduce individuals to stereotypes rather than looking at the full range of what they bring to the table as individuals.
Does anybody that you know in their own life, when they have to make own hiring decisions, a doctor, a dentist, an accountant, anybody take into account people's ethnic background, or even ask what their ethnic background is?
I agree that that would be unusual, and that for many individuals should value competence or what they bring to the job in their role as doctor or dentist rather than racial stereotypes.
Mr. Squires, could you comment on that? I mean, this idea that somebody's view of the world is based on where their ancestors came from and that they're a monolith. Could you comment on that?
Sure. I mean, it's unfortunate that we have taken that perspective. This is one of the reasons why I believe, quite frankly, many black conservatives are easy targets in the media, is because the moment they say things that sort of the progressive left don't agree with, they're attacked.
Is that part of the problem too? Is this a pretext design to force people of a certain ancestry to allow them to be promoted based on their ideology? I mean, I can think of an example that I have heard of in my own life in just employment, where somebody was a person of color, let's say, and they were therefore educated that they should have a certain viewpoint because they're of that ancestry. Is that part of the motivation here?
A very, very quick answer.
Well, I'll say this in general. I do not define diversity as having people of different skin colors who all think the same. So to the extent that post-secondary institutions want to promote diversity, I think diversity of ethnic background is fine, diversity of region, but it's particularly diversity of thought. I think those should be their goals, and not just the color composition of the classroom.
Thank you. I'd like to now recognize Mr. Gerald Paul.
Thank you, Mr. Chair. Race-conscious admissions was a critical tool for diversifying classrooms, for reducing racial bias, and addressing racial disparities in enrollment for students of color. Right-wing activists unfortunately waged a decades-long challenge to the use of race, and unfortunately they succeeded when the Supreme Court struck down this tool for achieving diverse classrooms by ending race-conscious admissions policies. My home state of Washington has had its own affirmative action ban, unfortunately, since 1998, restricting public colleges and considering race as an admissions factor. Despite the ban, half of Washington public college students are of color and just as diverse as their private college counterparts. One way that our Washington public colleges did this is through their guaranteed admissions policy. These policies promise seats to eligible students from local high schools if they meet grade or other academic requirements. It's not unique to my state. Colleges throughout the country have adopted similar policies without standardized testing requirements. Mr. Hinojosa, there may not be a policy that can help achieve racial diversity at the same level that race-conscious admissions has, but why are policies that eliminate reliance on testing helpful in diversifying student bodies?
Thank you, Congresswoman. So first, you have to know a little bit about standardized testing, right? They are incredibly biased instruments. They were started way back based on eugenic science, which has obviously been, dismissed by the scientific community. They're poor predictors of college success and college readiness, so there's no real connection to that. And they're basically or essentially your test score is predicted based on your zip code and the quality of education that you've received, or your socioeconomic status, I should say, rather than any other quality that an applicant would cover. So I think it's imperative that universities, especially in light of the ban, which has always been followed with substantial drops in students of color, that they consider race-neutral alternatives as those in Washington State, because those are trying to take students for where they're coming from. The high schools, there's lots of inequality still in K-12 education across all states. And I think it's imperative that they look to solutions that allow students to still show up with their talents and experiences and the like, and not just reduce them to a single test score as though that tells something about their talents.
Very important. It's interesting, but guaranteed admissions have even shown to help students graduate debt-free. For example, Washington State University has a guaranteed admissions policy, and their low-income students can attend tuition-free with our Washington College Grant. Supporting students in that way, I feel like, should be nonpartisan, should be bipartisan, but instead the same right-wing organizations behind the affirmative action decision have also waged attacks against guaranteed admissions. They claim it could be a form, get this, of race-based discrimination. But are you aware of any of these policies considering race as an admission factor?
Absolutely not. I mean, whether or not there's intentions to further diversify across socioeconomic status, across first generations, across language, et cetera, there's lots of qualities that even rural communities as well. I'm most familiar with Texas's top 10% plan because I was at MALDEF for many years and worked on both policy and litigation around the Texas top 10%, and that has helped improve. Sometimes it doesn't work as well, and this is how and why universities need the resources to be able to explore exactly how these race-neutral alternatives may impact it. But these absolutely have nothing to do with racial discrimination. They're not treating any individual differently based on their race.
And in fact, your witnesses next to you have been arguing for not reducing people down to one factor. Seems like standardized testing should not be a factor that people get reduced down to. Alternative admissions policies do not sound like a veiled racial quota like some on the right allege. In fact, guaranteed admissions seem to be the same type of race-neutral policies that these activists claim to want in a post-secondary education. Today, a witness argued that black students are harmed by policies that promise to uplift them, but instead result in mismatching them into academically challenging programs. As selective colleges reflect on their role in ensuring racial representation, should they be concerned about creating pipelines for underrepresented students in their competitive programs?
Yeah. Absolutely, they should. If we're supposed to think of our universities as engineering, economic opportunity for all, then those universities need to be open to those students. And the whole mismatch theory has already been debunked by real science. That soft science has been dismissed repeatedly by peer-reviewed studies and really shouldn't be echoed in any chamber.
Real science, what a concept. I yield back. Thank you.
Thank you so much. I'd like now to recognize Ms. Stefanik.
Thank you, Mr. Chairman. The Supreme Court correctly decided Students for Fair Admission versus President and Fellows of Harvard College when they held that Harvard College's admissions did not comply with the principles of the Equal Protection Clause embodied in the Civil Rights Act. Now, Ms. Soman, previously, Grutter versus Bollinger assumed that race would be only treated as a plus in the admissions process, but we saw at Harvard that in some cases this was treated as a minus. Is this correct?
Yes.
And can you expound upon that?
Absolutely. So when there are only a limited number of seats available at any given university, it's inevitable that a plus factor for some students will be a minus factor for others.
And particularly as a Harvard College graduate, I'm very concerned that in 2013, Harvard's own Office of Institutional Research concluded that the university system was indeed biased with negative effects in the admissions process. And isn't it a fact, Ms. Soman, that they buried this report?
Yes.
I have concerns in the wake of the Supreme Court's decision. In one of the mailings that was sent out to alumni, the headline was Harvard United in Resolve in face of Supreme Court's admissions ruling. Do you have concerns about the compliance of the Supreme Court decision at some universities?
Well, I'm not familiar with that particular mailing from Harvard. I have seen similar statements from the heads of other university officials. In an amicus brief filed in support of the Coalition for TJ Cert petition, the Cato Institute documented many such examples of evasions, so I'm very concerned about lack of compliance, yes.
And how would you identify potential lack of compliance?
So statements from university officials would certainly be concerning. Changes in policy that don't seem to make sense in light of academic qualifications, but that instead seem targeted at engineering a particular racial composition, I would be concerned about.
Mr. Squires, I wanted to turn to you. In your testimony, you mentioned that it's universities themselves that benefit, not the students, from race-based discrimination. How does Harvard and how do other schools actively maintain internal incentives to keep discriminatory policies in place?
Well, what I meant by that is that oftentimes universities will particularly focus, for instance, on the incoming class, the freshman class, and talk about how diverse it is. And part of the reason is because they want to receive the social benefits that come with being able to say, look at all the black and brown students we have. But again, there's a lot less emphasis on the graduating class. So this happens oftentimes when individuals will say they are choosing a particular candidate for a particular position based on race and sex. And what it does, it saddles that person with the burden of feeling as if they are not being judged by their qualifications, and allows the person doing the choosing to say how virtuous they are because of how progressive they are.
And Mr. Squires, how will the end of discriminatory race-based admissions help the next generation of college applicants?
I think one of the things that it would do is allow everyone on campus, ideally, to be able to understand that we are all here because we're based on the same set of qualifications. I can guarantee you that if in 2043, the highest performing students on the SATs and in terms of grades were black and Hispanic, no one on the other side of the aisle would say that too many of them are going to Harvard and Yale. So if we believe in equality, it has to be equal across the board, which means everyone has to be judged by the same set of standards. If we want to consider socioeconomic status, that has to be the same across the board. But what we can't do is say, for one group of students, you can come in at this particular bar, and for another group of students, you have to come in at a much higher bar.
Thank you. I yield back.
Thank you. And I'd like to recognize Ms. Bonamici.
Thank you, Mr. Chairman. I want to start by just noting that one of the witnesses contended that although qualified black applicants at highly selective schools have earned their place, they are a small number of the total black applicants who are admitted. And I'd like to enter into the record an article by Forbes titled "Black Harvard and Princeton Students Graduate at Higher Rates Than Their Classmates Overall and Equally at Yale." The article highlights Department of Education data that shows a 99% graduation rate for black students at Harvard compared to 98% for all students, a 99% graduation rate for black students at Princeton compared to 97% of bachelor's degrees seekers overall, and 98% of Yale students graduate within 6 years, exactly the same for black Yale students. I'd like to enter that into the record, Mr. Chairman.
Oh, yes, with no objections.
Mr. Chairman, our nation's colleges and universities play a key role in preparing people for the jobs of today and the jobs of the future. They're an important part of preparing, for example, the highly qualified workforce we need to maintain our nation's technological leadership and advance our national security interests. And in all of these areas, we benefit from a multiracial and multicultural student population that brings a wide range of perspectives and life experiences, including at elite colleges and universities. And in fact, Chief Justice Roberts noted this in his point in the opinion in Students for Fair Admissions, saying that race-based admissions programs at military academies could further compelling interest at such academies. Mr. Zhao, do you agree that there's a range of factors to consider in advancing the United States national security interests and its global economic and technological leadership, including preparing a workforce that reflects our nation's racial and ethnic diversity? And that's a yes or no question.
I think number one, the college should promote the diversity of ideas, right? Students benefit from that. Also, our nation will benefit recruiting the best and brightest and give them best education.
Yeah, I'm going to reclaim my time, and I just want to enter into the record again, Mr. Chairman, excerpt from an amicus brief submitted in the case by major American companies, including American Airlines, GE, GM, Intel, Johnson & Johnson, and others, titled "American Businesses Rely on Universities to Create a Pipeline of Diverse Leaders Equipped with the Skills to Thrive in the Global Marketplace."
No objection.
Thank you, Mr. Chairman. And Mr. Zhao, in your written testimony, you mentioned your concerns with unfair admissions practices such as legacy preferences, and I'm glad we share that concern. But you also mentioned that legacy preferences are driven by, and I quote, racial equity ideologies. Are you aware that legacy students are disproportionately white? For example, 7 in 10 at Harvard. That's a yes or no question.
That is a historic fact, I believe.
Okay, thank you. And I want to follow up on Mr. Takano's line of questioning, Mr. Zhao, because you discussed meritocracy several times. In your testimony, you talk about restoring meritocracy and do not destroy meritocracy. But you appeared to define that meritocracy based on test scores and grades. The dictionary definition of meritocracy means based on ability and talent rather than wealth or social position. So I submit that many people have tremendous ability and tremendous talent and potential and might not have high test scores or high grades. So it seems like it's sort of counter to what you're saying, and I wholeheartedly reject the notion that meritocracy and racial diversity are somehow exclusive, and saying so is sort of tantamount to claiming that Black and brown students aren't academically talented enough, or as Mr. Squires claims, mismatched. Now that view ignores a whole range of assets, experiences, and perspectives that Black and brown students bring to our nation's colleges and universities. And in fact, do you know what the PISA scores are, the international test scores?
Yeah, I would think, Congresswoman, you misinterpreted my statement. I was saying, the test score should be one of the key criteria.
Yeah, I understand that that's what you're saying. I'm reclaiming my time, and I just want to note. I'm reclaiming my time, Mr. Zhao. I just want to note for the record that in countries with high PISA scores like China, South Korea, Singapore, they're pretty low on entrepreneurial skills, but in the United States, where we might on PISA scores have lower test scores, we have higher confidence in entrepreneurial skills. I think that's important to keep in mind. Real quickly, Mr. Hinojosa, based on your understanding of the Supreme Court opinions, would targeted outreach and recruitment policies and other policies that are outlined in the recent joint guidance from the Department of Education and Justice run afoul of the opinion, as some of my colleagues have claimed?
Are they prohibited?
Would they run afoul of the opinion?
Absolutely not.
Thank you, and I appreciate that, and I'm just about out of time, so I yield back. Thank you, Mr. Chairman.
Thank you so much. I'd like to now recognize Ms. Fox, Dr. Fox.
Thank you, Mr. Chairman. Thank you for leading this hearing today. For far too long, college admissions have pitted students against students based on race. This is undoubtedly a great stain on our post-secondary education system. But today should be a day when this committee can look forward to a brighter future for all students. I'm most encouraged by universities that have committed to change, and am proud that the University of North Carolina, Chapel Hill has chosen to look forward. On the day of the Supreme Court's decision, UNC Chancellor Kevin Guskowitz shared with the UNC campus community, "We will follow the Supreme Court's decision in all respects. That means race will not be a factor in admissions decisions at the university," and didn't stop with just words. UNC is educating undergraduate admissions officers on the new legal standard. The university has reviewed admissions applicants for graduate degree programs, and the university has made technology changes so no one who makes admissions decisions has access to applicants' racial, demographic data during the admissions season. It's my hope that many other colleges and universities are taking the same step. Mr. Squires, we know it's important to provide more than just access to college. Schools should be equally focused on helping students complete college. You mentioned in your testimony that highly selective schools using race-based preferences run the risk of creating a mismatch between the student and the university. How important is it for a student to be prepared to meet the academic rigor of a university, and what might a mismatch result in?
Thank you for that question. It's incredibly important, and particularly in the hard sciences. So if you are an engineering student who comes into a school, and let's say you scored a 650 on the SATs in the math portion, very good score, but your peers on average scored a 750, and you're in a class that's taught at 750 speed, physics or calculus, you are going to fall behind. And what some of the research has shown is that oftentimes black students are more likely to major in STEM disciplines at selective schools, but also more likely to switch out of those majors. Mismatch is an issue, but I want to say something really quick. I think part of the problem is that we've adopted in this country a college or bust, and particularly an Ivy League or bust attitude that makes people believe that if you do not attend college or an Ivy League institution, that to some extent you're wasting your life. And I think that is the wrong way to go about talking about higher education. But again, regardless of what school we're talking about or what institution we're discussing, at the end of the day, the admission standards should be consistent across the board and not based on a person's skin color or ethnic background.
Oh, thank you very much for that. Ms. Soman, do you have anything to add to that?
So I thought Mr. Squires gave a very nice summary of the basic concept and how it applies in the engineering area. I would add that there's been similar empirical work showing mismatch effects in law and on law students' eventuality to pass the bar exam. There's been further work conducted by Eleanor Barber showing that it affects minority students' ability to obtain graduate degrees and go on to careers in academia. Finally, I would add that there's nothing that's unique about mismatch effects to the racial context. When Peter Arcidiacono and his colleagues at Duke University were studying mismatch, they found that students who received legacy preferences in admissions also tended to drift away from science and engineering because they tended to come in with lower average academic credentials than their peers. This isn't about race. This is about differences in preparation affecting your likelihood of success in a particular curriculum.
Oh, thank you very much for adding that about the legacy admissions. I think that's useful. Mr. Zhao, you talked about how you lived your American dream. You've worked tirelessly to represent AACE's mission to achieve equal education rights for Asian Americans. Why is this mission still important today, even after the Supreme Court's decision against race-based preferences in admissions?
Yeah, it's very important. We notice like U.S. Department of Justice and Education issue the guidance, even encourage the continued use of race and proxies at the national level. In California, the Democrats reintroduced ACA 7, try to reintroduce the risk fact in the admission of the California school system. As Ms. Salman mentioned, in high school around the country, they have assault on the meritocracy to cancel the admission test for Thomas Jefferson, Boston exam schools. So basically, unfortunately, the advocates of the racial diversity and diversity, they have not given up. So we have to continue on this fight.
Thank you, Mr. Zhao. Thank you, Mr. Chairman.
Thank you so much. I'd like to recognize now Dr. Adams.
Thank you very much, and thank you all for your testimony. Mr. Squires, you stated in your written testimony that highest performing black applicants at Harvard have close to 60% chance of being admitted, and for black legacy student, that number rose to 99. So when you're talking about high performance students, are you referring to their test score and the grades for admittance?
Yes, that was in reference to how Harvard categorizes and breaks down and scores its students by decile. So I was talking about the 9th and 10th decile. So they use test scores and grades, correct?
Okay. So, I just want to note that because a student isn't, quote, high performing, and then when we're talking about affirmative action, it doesn't mean that they don't deserve the chance to have access, and that's really what affirmative action provided for these young people. So let me move on. Mr. Hinojosa, the media has portrayed the holding in this case to be that affirmative action has completely been overruled. And some of the witnesses here have interpreted the opinions holding to be even broader, eliminating any consideration of race in higher education at all. Your oral testimony gave us your legal take on the court's holding. But as an advocate who represented UNC student interveners at the Supreme Court, what does this holding mean to those students and to their interests at UNC?
It means that racial equity still matters in America. You know, we hear about lots of testimony here today about individuals being treated individually, but for 300 plus years, individuals weren't treated individually, and those people were Black, Native American, brown students, among others, even Asian American students, for far too long, and they should have opportunity. And just because you can't consider race, so let's remember, the decision says that the way that Harvard and UNC considered race was unlawful, but it doesn't mean that you still cannot pursue diversity in its broader breadth, including racial diversity, through race-neutral means. What they were concerned, and Chief Justice Roberts was specifically concerned with, was a student getting an automatic bump just because of their race. And that actually wasn't really happening in many places, not even at Harvard and UNC, if you look at the real record, but that's what they suggest, you know, are these race-based considerations. But for the students, it means having all their talents, all their experiences fully evaluated, and them being able to express this in their applications and have that fully considered. And they should not be censored.
Okay, I agree. You stated also that increased funding levels for historically Black colleges and universities, HBCUs, Hispanic serving institutions, tribal colleges and universities, Asian American and Pacific Islander institutions, that they may see a dramatic increase in applicants and admitted students who are no longer able to gain admission into colleges and universities that severely restrict the use of race. So can you talk a little bit more about the impact that restricting the use of race and admission will have on these institutions, and the ways in which these HBCUs, HSIs, TCUs can prepare the universities for the influx of applications?
Sure. Typically what follows bans on affirmative action, we know this from Oklahoma, Michigan, California, Texas back in 1997, you have large dips in underrepresented students of color. Some of that is because students are no longer applying to universities because they don't feel like they might not get in, so they're undermatching themselves to other institutions. Others want to feel more welcomed, and they may not feel as welcomed at certain universities, especially state flagships and other universities as well. And so it's imperative that HBCUs and other institutions, that you named and we name in our report, they're going to be experiencing a large influx of applications from students, who want to go there for lots of incredibly important reasons. They're incredible institutions and show a lot of promise, but they will increase with the applications they receive because students aren't applying to other colleges that they may end up applying, but instead apply to HBCUs and the like.
Okay. Just quickly, how can admission officers comply with both the SSFA holding and the Title IV?
The holding in what?
The SSFA holding and Title VI. Are there any strategies or policies that can widen this area for them?
Yeah, we have many of those in our written testimony, and the Department of Education, Department of Justice also list a number of options. The door is not completely closed to ensuring equal opportunity for all.
Thank you. I'm out of time. Thank you. You're back.
Thank you. I'd like now to recognize Mr. Good.
Thank you, Mr. Chairman. Thank you to all of our witnesses. Mr. Zhao, a review of the 65 universities is in the so-called Power 5 athletic conferences found that the typical institution has 45 DEI staff members on its payroll. So 45 at the typical Power 5 institution, which is 4 times the typical number of employees devoted to supporting students with special needs. And by the way, colleges are increasingly offering, as you know, DEI programs of study for students. Given this growing number of DEI offices and positions on campus, how might that impact discrimination in other aspects of campus life?
You know, I want to tell you, China experienced similar things during Cultural Revolution. Colleges, institutions established revolutionary, committees to distract the, institutions' main task, right? So I think our, educational institution should going back to its basic, its goal to really educate, to recruit the best and brightest, and provide the best education instead of promoting some ideology. That's my take on that.
So focus on education, academic excellence. Is there any return on investment for this spending on DEI positions besides raising tuition costs for the university?
I have not seen that. I see the more negative impact, just like the Revolutionary Committee did to China about 50 years ago.
Thank you. Mr. Squires, I know this has been talked about today, but can you just characterize the difference for us again, between equity and equal opportunity? What is the difference? We use that term equity and what the goal of that is versus equal opportunity.
So the way equity is typically used in sort of common parlance is suggesting that people from all different types of backgrounds end up in the same place. But the actual definition of equity is the consistent and impartial application of a particular standard. So the equality of opportunity, again, to me, you're talking about being able to bring people from different backgrounds and, again, subject them to the same types of standards. So for instance, a city may say, we want to see SAT scores improve, so we will provide free testing at high schools across the city. Those types of things provide equal opportunities. Equity is when you turn around on the back end and say, and again, particularly in the college context, and say, okay, we see that everyone is not coming in with the same types of score, so now we're going to socially engineer the demographic balance on the back end.
I appreciate that, and I would submit that the focus on equity is perpetuating the harm done from previous years of discrimination and a lack of equal opportunity. Wouldn't you suggest that those who support equal opportunity should also support school choice?
Absolutely. I believe school education choice, whether through the expansion of charter schools, vouchers, particularly education savings accounts, has to be one of the highest priorities as we move forward in a world post preferences. But a lot of people like to talk about race as it relates to higher education, but here's how the interaction of race, class, education, and politics actually works today. Black progressives, particularly politicians in the media, will rail against school choice on the K through 12 level, particularly vouchers, oftentimes being supported by teachers' unions. They send their own children to private schools.
Right.
They summer on Martha's Vineyard, and then when it's time to apply to Harvard, they turn around and cite education disparities in the inner city to justify why their children need racial preferences. So to me, if anyone wants to talk about, race and education and outcomes, and they are not for education choice, I think that's a big problem. And I'll submit, I'll make a quick policy suggestion for the committee's hearing. I think any elected official, regardless of their jurisdiction, who stands against school choice should be required to send their child to the lowest performing school in their district. Because if the schools are not good enough for your child, then they shouldn't be good enough for mine either.
Well said, Mr. Squires, and I encourage everyone on the committee to support my Choice Act, which allows federal dollars to go and follow the child to the educational opportunity of their choice, or the parent's choice, and it particularly, obviously, is for those who are of lower income. Last question, Ms. Salmon, thank you for being with us today. Fairfax County in Virginia, the state where I'm from, has moved towards equitable grading. Could you talk briefly about that equitable grading and the harm that's being done from that?
I'm not familiar with the policy.
Okay, well, equitable grading is its stated goals to combat institutional bias and eliminate racial disparities in grade outcomes, and it removes grade penalties for late assignments. And so, but I see I'm out of time as well. I yield back, Mr. Chairman.
Thank you so much. Appreciate that. I'd like to now recognize Mr. Courtney.
Thank you, Mr. Chairman. Mr. Hinojosa, one of the traditional strengths of our system of laws, common law as well as legislating, is the principle of legal certainty, which is that to the, and it's been expressed, is that the law must be accessible and so far as possible intelligible, clear, and predictable. I mean, people rely in terms of just organizing their lives and their enterprises, in terms of just having clear signals from courts and legislative bodies, in terms of following what I think has really always been a really important and positive principle. Your testimony on page 5 notes that for those who think that the court made the admissions process completely race blind. In fact, as you point out, there is language in there that suggests that there still, is under the law the ability to, conduct admissions in terms of how race has affected an applicant's life, be it through discrimination, inspiration, or otherwise. So I was home in August and talking to some educators in higher education, as well as other secondary school institutions in Connecticut. And I have to tell you, the principle of legal certainty was completely trampled by this court. And again, setting aside all of the political arguments that are here today, I mean, the fact of the matter is that if you're in an admissions office right now trying to figure out, with this decision about how to make choices in terms of applications, I mean, it is really almost just chaos in terms of just trying to decipher this. I mean, they are talking about actually bringing on legal counsel, to really screen sort of what the court actually left them with in terms of this decision. So I was wondering, again, I know the DOE is talking about trying to get some guidance out there, but the fact of the matter is this court has really left a mess as a result of this decision, regardless of how people feel about the merits of affirmative action.
And that mess started with the court's own unjust, tortuous interpretation of the Equal Protection Clause, even suggesting that Brown v. Board somehow would support excluding Black and brown students, highly qualified Black and brown students, from our nation's most selective institutions. And that's sad. I carry a copy of the same pocket guide that I got from the University of Texas School of Law when I went there back in the 1990s. And but what's most troubling about the more recent opinion is that you have Chief Justice Roberts almost trying to dictate educational policy. He's a Chief Justice. He should limit his opinion to the issues that are before him, but he didn't do that, and he started trying to write, policy, and which has thrown confusion. But it's been made even worse by organizations like Students for Fair Admission, suggesting that the whole process has to be race blind. That absolutely is not. If Chief Justice Roberts, just as an example, if Chief Justice Roberts says, yes, you can consider race as a notion of resilience and the like, right? And overcoming discrimination. So how can you talk about racial discrimination, overcoming racial discrimination, and somehow have to divorce race from overcoming race discrimination? It doesn't make sense. But when you talk to lawyers, they will tell you that's what the opinion means. And that's why we have, some chaos that's been created in many boardrooms at colleges and universities and in K-12.
Well, again, this seems to be a trademark of the Roberts Court. I mean, if you look at the Dobbs decision, I mean, it's the same situation that's happening in hospitals and clinics all across the country, where OBGYNs are feeling the need to have legal counsel to advise them about how to practice medicine. Because again, it's just, they've created all these cross currents of possible criminal liability as well as professional liability in terms of just stepping outside lines that are not clear in terms of just how they're supposed to practice medicine. Again, moving forward though, I mean, it's clear that in my opinion, Congress needs to act to set some clarity so that we can, again, allow our legal system to achieve a goal that has always been, recognized as essential.
Yeah, and we need to make sure that students understand that their full experiences should be represented, and that universities shouldn't shy away from that. In fact, they might be running afoul of students' First Amendment and 14th Amendment rights if they try to censor students' stories simply because they're related to race.
Thank you. I'd like to now recognize Mr. Moran.
Thank you, Mr. Chairman. Ms. Salmon, I want to come to you just for a little bit of response for Mr. Hinojosa's criticism of Chief Justice Roberts. When you look at his writings, and he said in particular in the most recent opinion we're focused on today, about the dissenting opinion, that he said, the dissenting opinion defends, quote, a judiciary that picks winners and losers based on the color of their skin. What would be the consequences if our judicial system applies different laws based on race?
I agree that that would be very concerning. Individuals should be treated as individuals when they come before the law, and a judiciary that doesn't do that I would be very concerned about it.
Last week, the Students for Fair Admissions filed another lawsuit against West Point Military Academy, U.S. Military Academy at West Point, and the Department of Defense, citing the military academy's use of race as a preference in admissions. In fact, West Point publishes racial composition goals for every class, and these goals are adjusted yearly to reflect the enlisted population. During the Students for Fair Admissions Harvard and UNC oral arguments, what was the discussion around the military academy's race preferences?
There was a discussion concerning whether this was the kind of compelling interest that would evade strict scrutiny that would allow the military academies to use race.
And given the Students for Fair Admissions decision, how might the courts rule in the West Point Military Academy lawsuit? Do you have an opinion about that?
The Students for Fair Admissions decision makes it clear that what's known as strict scrutiny applies to the use of race in admissions everywhere, including the military academies. Any use of race must serve a compelling interest and must be narrowly tailored to serve that compelling interest. That is, the institution can't use race any more than is necessary. In the military context, what that compelling interest might look a little different than the civilian context. Nonetheless, given the toughness of the standard enunciated in Students for Fair Admissions, I'm skeptical that the military academies will be able to meet that heavy burden.
Okay. Mr. Squires, I want to come to you now for a few questions, if you don't mind. In an article that you and your colleagues from Heritage wrote titled Created Equal, a Roadmap for an America Free of the Discrimination of Racial Preferences, it states, quote, ending racial preferences will provide opportunities for policymakers to focus on often neglected factors that contribute to student success. My question to you generally is, what are those neglected factors that you were referring to in your colleagues when you wrote that article?
So I believe what we were referring to in our special report that came out after the decision, particularly was around family and family structure. And as I said, the research is conclusive at this point that children raised in two-parent homes by married parents tend to do better on a host of educational and social outcomes, better than any other family arrangement. But for some reason, this is not seen as a priority oftentimes with respect to our policy, and I think it's something that we need to discuss more. And obviously, we can't fix this in one particular generation, but that's part of the reason I talked about the success sequence, so that children, way before they start a family, understand that they have a sense of agency. So if they finish school, get a job, get married before they have children, their chances of being in poverty will be in the single digits. I think it's something that every student should know before they graduate from high school.
Yeah, and you anticipated my very next question, because I wanted to raise that quote from your testimony, because it was astonishing to me to look at that and know that that is in fact a great recipe and a great formula to getting out of poverty, is to stay in school, to secure stable employment, to get married before you have children. Those factors are much more prominent than anything else, and so that traditional family environment is so important to raise our kids up and to allow them then to succeed and to do much better than we did. And that was one of the things, as I look back on my upbringing, that I credit a lot of where I am today to, is certainly was not money, certainly was not influence, but it was the stability and the security of loving parents that guided me through that time to understand that my decisions would help me get further in life by working hard and by serving others and by instilling good values in me. Would you agree that that is a good formula ultimately to lead to success in this world?
Absolutely. If the first time your child is read to is when they start on their first day of kindergarten, something has gone wrong, regardless of what skin color that child is. So home environment matters a great deal as it relates to education. And I think of my own father, who was the chief education officer in our home, who stayed on me consistently because he refused to allow me to settle for a B+ when he knew that I could be an A student. So students need obviously quality schools with dedicated teachers and administrators, but they also need to have the types of home environments that cultivate a sense of wonder and a lifelong love of learning.
I love what you just said, and I'll yield back by finishing by saying this. I started my day out this morning talking to my first grader and my second grader back home on FaceTime, getting them to show me the books that they had checked out from the library and talking about their reading levels and what they needed to accomplish this week in school. It's very important. I yield back.
Thank you. I'd like to now recognize Ms. Ledger Fernandez.
Thank you so very much, Mr. Chairman and Ranking Member and our witnesses. You know, in New Mexico, in Nuevo Mexico, we pride ourselves on our diversity. It's the foundation of our state's unique and beautiful culture, and actually looked at across this country as what could a diverse nation look like? Well, it looks like New Mexico, and we're very proud of that. But New Mexico's colleges and universities, well, they also reflect that diversity. We have 30 minority-serving institutions, including 4 tribal colleges. But I'm here to say it wasn't always that way. Latino and Native American communities had to fight for their rightful place in our higher education system, because we know it's not just how much love you have at home, it's how much education you can get to go on and accomplish the things like sitting in Congress. Under the GI Bill, this is a story I say often because people don't think about it when applied to New Mexico, but under the GI Bill, my father and other Hispanos and Jews could go to our local university. But guess what? The white-only fraternity barred them, banned them. So we can see that there has been, in this beautiful state of mind, active racism, active discrimination. But what happened to that university? It became the country's first university with a Latino president at its head. And at UNM, which is our flagship university, it went from about a 31 to about a 51% Latino population in 25 years because they worked at it. They wanted their universities to reflect their state. You have to put in the hard work to make sure that our institutions reflect, like I like to quote John Adams, in miniature, the diversity that is our country. That's our founding father who recognizes the importance of diversity. And we've seen study after study that economic, education, democratic benefits that flow when you have diversity, that in so many different ways, the Supreme Court and Students for Fair Admissions versus Harvard ignored that fact. And I want to thank you, Mr. Hinojosa, for the amazing work you did to bring those benefits to light. But the decision is the decision. There are those of us who don't agree with it, but we must live by it. But that doesn't mean that we can't still work to diversify our educational institutions. Can you tell us in Congress what we can do to make sure there is more diversity at our colleges?
Yeah, and I do want to say, I'm a New Mexico State University grad, so go Aggies.
Maybe not flagship, one of our important universities. How about that?
The other flagship, as we like to say. But there's lots of options, for university, and they have to think of things comprehensively, right? Affirmative action was never the silver bullet, right? It wasn't going to get us where we needed to go. Again, it wasn't, these automatic admissions. There's plenty of extremely talented students across races and backgrounds who have been admitted through affirmative action programs. Now we don't have that as an option at most universities. We still have it available at the military academies and possibly others for other reasons, but there's still other opportunities. There's the analyzing race-neutral programs, such as percentage plans that were mentioned earlier in Washington State. Students attending their schools, should be able to attend, their state flagship. These are state flagships that should be representative of the state. And we're not talking about racial balance, and we're talking about access in a true democracy. We're talking about need-based financial aid that needs to be increased considerably. Climate support. So these DEI programs that were mentioned earlier, those are actually pivotal to providing the support and building a healthy, inclusive climate that does help broaden perspectives across campuses and the like. And there's many things that Congress can do. We have a lot of options in our written testimony about how Congress can also help move the bar to ensure that racial equity is not written out of policy in our universities and institutions.
And in your written testimony that you just referenced, you also pointed out the importance of Pell Grants, because Pell Grants will help students from diverse socioeconomic, diverse racial backgrounds, but with socioeconomic need access. And I would point out that House Republicans proposed earlier this year to reduce Pell Grant funding by 22%. Imagine that, 22%. 80,000 Pell Grant opportunities go away. I'm going to have to ask you to perhaps elaborate on that in writing, because I have run out of time, but that is a way where we are cutting opportunities across our country for our most deserving students. Thank you, Mr. Chairman. I yield back.
Thank you. I now recognize Mrs. Scott.
Thank you, Mr. Chairman. Mr. Squire, you mentioned that race should not be the only measure of diversity. I think everybody would agree with that. You ought to look at all kinds of diversity, but does the college have the right to try to have a truly diverse college students because they're going to learn from each other and they're trying to be prepared for a diverse workforce? Doesn't the college have a right to try to have a diverse student body?
I think colleges have a right to, determine admission standards. Again, I'm not opposed to a diverse student body. I'm actually very much in favor of a diverse student body. Again, part of that may be ethnic, but again, a big part of it is in terms of diversity of thought.
There's value to diversity of the student body because students are learning from each other, and you're not going to learn much from a socioeconomically homogeneous student body.
Well, if a selective college has 100 students, equally broken up into black, white, Hispanic, and Asian, and all 100 went to Sidwell Academy, I'm not sure how much diversity you're actually going to get. So you may have people who look differently, but in terms of their life experiences, they very much may be very much the same. So I think...
So they should try to diversify that.
What I'm saying is people on the outside will look and say this is very much a diverse class, and what I'm saying is the people will look the same.
But, okay, you can define diversity, but I think you're trying to say we should have as diverse as possible. Ms. Sumlin, you mentioned that the military academies should be diversified. Can you show why they need to be diversified and why that argument wouldn't apply to other colleges?
So what I said was that the compelling interest in diversity may look a bit different in the military context than the civilian context. That said, strict scrutiny still applies to any cases involving the military academies, and I'm not certain that the military academies will be able to prove both that their use of diversity is in fact a compelling interest and that the way that they are using race is narrowly tailored to serve that compelling interest.
So you don't think diversity in the military academies is a compelling state interest?
That will need to be developed in the course of litigation. I agree that whether it's compelling, the analysis will look a little bit different than in the civilian context, but the legal standard they have to meet is still high.
If a plaintiff could prove that an admissions test is in fact discriminatory, should it be allowed?
If a plaintiff can prove that a test is discriminatory, intentionally so, then that violates Title VI and possibly the Constitution at a public university.
And a legacy program where the state, like Virginia, had a policy that essentially prevented most African Americans from attending predominantly white institutions like UVA and Virginia Tech. Would a legacy program where they would not benefit by having grandparents that went there, should that legacy program with a discriminatory impact against African Americans be allowed?
Under Title VI, a program has to be intentionally discriminatory to be prohibited. The plaintiffs or challengers would have to show that a particular program is intentionally discriminatory.
So if it's just discriminatory but not intentional?
So I would distinguish between programs that have a disparate impact, that is, those that have an adverse effect on a particular racial group, but that aren't necessarily intended to be discriminatory. Title VI is not a disparate impact statute. It is what's known as a disparate treatment
Ms.
statute.
Hinojosa, we know these tests are discriminatory, that legacy is discriminatory, athletic admissions can be discriminatory, wealthy donors get in at a higher rate. When people talk merit, how fair is it to have merit without offsetting all those discriminatory impacts with affirmative action?
Yeah, I think certain parts of America, and some which are represented here today at the hearing, have such a jaded view of what meritocracy really is about and what merit is about, trying to suggest that it's anchored in many of these systemic oppressive barriers, such as legacy admissions and such as standardized test scores that really tell you nothing else about students, and they're simply used as barriers to admission to prevent certain people, including the Black and brown communities, Native American communities, from attending certain universities, and it helps them excuse it and perhaps to sleep a little better on it, suggesting these are objective.
So, sorry, time's up. Well, you indicated that the Supreme Court did allow race to be used to a certain extent. Can you elaborate on that?
Yeah, so the Supreme Court held not that affirmative action itself is completely done away with. Race-based admissions programs, in the way that the Supreme Court suggested that they're operated, cannot continue in the way that Harvard and UNC were doing. But they can occur still at military academies because of their national security interests. There might be other interests that are defined as compelling. The court said that the way that Harvard and University measured their compelling interest in diversity was not measurable, that it was not linked to their specific goals, and that they had no end time limit on. But if a university was to identify compelling interest, for example, if a university wanted to make sure that all its doctors were leaving a medical school community and they were leaving certain parts of the
I'm going to have to
community.
interrupt. We have to close up. Thank you so much.
Thank you,
Appreciate
Chair.
it. Okay, I'd like to, first of all, thanks again for everybody for answering those questions. And I'd like to now recognize Mr. Scott for his closing statement.
Thank you. Mr. Chairman, I think it's clear that colleges have a right to have diverse in many ways student bodies. They learn from each other. The experience of a 4-year on-campus liberal arts degree is such that you come out as a different person, and a lot of that transformation has nothing to do with what happens in the classroom. It's working with the other students. And if you have a homogeneous student body, you're not going to learn nearly as much from your students as you have from if you have a diverse student body, and that's part of the educational process. We've heard some of the solutions with school choice, and let me just say just very briefly, school choice helps a few people that can choose, but it diverts money from the overwhelming majority, and some of us are trying to help all students, not just a privileged few. But the so-called merit that we're talking about, and Mr. Hinojosa has gone into good detail on this, most of that is in fact discriminatory. The standardized tests have been studied, and they have a discriminatory impact against African Americans. And you can say whether it's intentional or not, but that's a fact. And it's not fair to have a discriminatory test, discriminatory legacy admissions when African Americans could not, because of public policy, go to predominantly white institutions in Virginia, and therefore cannot today benefit by having a grandparent that graduated from UVA or Virginia Tech. That should not be a factor. The fact that your parents can have make huge donations, I think the wealth disparity between black and white is well known. All of those factors have discriminatory impact, but they were offset by affirmative action. Now, without the affirmative action, all you have are these discriminatory impacts, and that is a clear violation of Title VI. It's discrimination, and we have to do something about it. Now, I don't know what we're going to do about it. You got to have some kind of standards, but if all the standards you come up with are discriminatory, that's a problem. And if you want to know what to do, ask the Supreme Court. They're the ones that came up with this idea, not me. But you can't end up with just factors that have a discriminatory impact and then try to hide behind the fact that it wasn't intentional and therefore not actionable under Title VI because we don't have a private right of action. So I want to thank our witnesses, particularly Mr. Hinojosa, who pointed out the discriminatory impact of what's left after affirmative action and the challenges we have to make sure that equal opportunity is alive and well.
Thank you again for our witnesses here. This is such an important topic. Let me just kind of set the record straight for those who are not aware of this. Failure is not in the DNA of Black Americans. Black Americans can think as well if given the same opportunity as any other American. For us to enter this conversation thinking that Black Americans, because they're Black and because they had slavery 200 years ago, are inherently less intelligent is indeed racist. Do not, and I'll kind of go back to a real quick point. My dad was born in 1928. Segregation was very, very strong those days. His dad was dropped out of second, third grade and went on to be a business owner. My dad in 1950 got his PhD at Ohio State in agronomy, and went on to make circles around men and women at the same time that were not his color because he was taught about meritocracy. That generation was taught that if you want to go out and win, you work harder, you study harder, you run harder, and you do not feel sorry for yourself if bad things do happen. You man up, woman up, grit, and get through it. Today, if that same success story would be to my dad, they would say he got through because of affirmative action, which is an insult to him and everybody else that before and after him. We have an issue, a problem right now, where Black Americans, 75% in 2017 of Black boys in the state of California could not pass standard reading and writing tests. Do you think they'll ever sit in this room succeeding? Do you think they'll ever go to college or whatever and succeed? No. Just recently, a couple days ago, Baltimore, 13 districts, 0 proficiency in math. Now, affirmative action could get them to a college, but guess what's going to happen? They're going to fail. They're going to be upset. They're going to think the system's against them because they've not been prepared. We're going to look at Super Bowl game this coming year. No one will ever talk about the fact there's discrimination and meritocracy because they know the best talent is on the field that day. Those guys who got on that field, whether they're Black, whites, Hispanic, it doesn't matter how tall or short they are there because they proved themselves to be the best prepared to win the game. We can do the same thing intellectually. Do not allow this country to go down that pathway of thinking because of our color, we can't think, we can't compete. It is very, very, what's the word I'm looking for? Insulting. So I want to thank you guys for this conversation. This is very helpful. I want to thank my colleagues for America to have this process of thinking through this, what we're going through right now, was to be on the other side of affirmative action, which for 60 years has been a detriment to many good people. We're now in the process of seeing how can we now make sure that we have a level playing field, that our kids come out of the school system, they can compete, feel good about themselves, and when they get to that position of success, never feel they have to apologize because they were given a head start because of their color. I'm excited about this process, and we're gonna find some solutions. I'd like to again thank our witnesses for taking the time to testify for the subcommittee today. And without objections and no further business, the subcommittee stands adjourned. Thank you so much.